We now move on to the Southampton SCR case review and related issues. In February 2012, a police investigation resulted in a male foster carer being convicted of 18 offences of historical sexual abuse. The perpetrator had been a registered foster carer from the early 1970s until 2003, around about 33 years, and fostered children from Hampshire County Council until 1997, and after that date for the newly formed Southampton City Council. So, as a result of further intelligence, the police operation was widened to cover other non-recent child abuse. This included considerations of allegations made against foster carers. On the 16th of May 2016, perpetrator 1, who we discussed earlier, was convicted of further offences and given an extra 4 years in prison. Perpetrator 2 had admitted downloading images of children, but as a result of Operation A, he was indicted for a total of 13 offences, and this includes 2 times rape of a foster child, 1 times rape of a family member, 1 times indecent assault of a foster child, 7 times indecent assault of a family member, 2 times indecent assault of a family member. At court, he was found guilty of all 4 counts against family member 2, but was not found guilty of the rape or of another family member. The overarching purpose of this review is to identify lessons that can be learnt both locally and nationally to improve the safety of children and young people in foster care. Although there are local variations, the standard tool used across the UK for the assessment and approval of foster carers is the Form F. This was first developed by BAF, and since 2000 this has adopted a competency-based approach to assessment. There has been criticism that this focus on demonstrating competencies could become a tick box exercise and not focus well enough on the relationships or analysis of the information gathered. As a result, the Form F was significantly revised in 2014 and has now removed the competency grid and contains text boxes headed analysis. There are several issues on the file that should have informed action and decisions before 1994. Several comments during preparation for fostering interviews regarding inappropriate boundaries, including he quickly gave the impression of trying to flirt or confuse me or provoke me by flip comments he made. Delay informing the local authority that the perpetrator 1 was subject to an assault charge for which he pleaded guilty. In November 1983, there was a file record that perpetrator 1's wife slapped a foster child's face twice and perpetrator 1 tanned her backside. Perpetrator 1's affair with a married woman he had met in a pub, and the fact that they gave up fostering for a few years due to the marital difficulties. Perpetrator 1's brother having been convicted of an indecency charge in 1988. Racist comments made by perpetrator 1. Reluctance to engage with a new review system. The family were in some financial difficulties, and in 1994 perpetrator 1 started employment as a night superintendent at a school for children with emotional social and mental health needs. Perpetrator 1 and his wife quickly became powerful figures who would readily challenge decisions and went on to use the complaint system as one way of controlling the authorities. For example, in April 1995, there was a note in the file that a decision had been made not to place a girl with them, as she would be with 2 boys. This decision was challenged by Perpetrator 1's wife, who said that neither she nor her husband were happy with the decision, as they felt that this implied they were incompetent. Within 2 days, the placement of the girls had been agreed. Perpetrator 2 and his wife were approved as foster carers by Hampshire County Council in 1994. They had raised 4 children, all boys, who were teenagers at the time. The Fostering Assessment Form S is probably representative of assessments at the time, in that it relied on self-reported information with very little analysis or challenge. For example, Perpetrator 2's wife described an unhappy childhood, but there was little exploration around how this might affect her own parenting. References were taken up, both of which were negative. One reference wondered how they would cope with fostering, as they were not organised and would not seek help if needed, and the other thought that Perpetrator 2 was a Peter Pan figure who preferred the company of young people. And his wife was unsure of herself. Instead of exploring the issues raised further, 2 more references were sought, which provided positive comments. The carers concerned were seen as a useful resource, as they were willing to look after children whose behaviour was deemed to be challenging. The focus on the challenging behaviour, which at times included the child's history of making allegations, meant that too often the problem became the child's, rather than being seen as potentially caused by the care they were receiving in placement. Overall, the focus was on supporting foster carers rather than challenging their behaviour. Whilst providing support to foster carers is crucial, this needs to be balanced with effective supervision and challenge. Fostering social workers need to develop skills in balancing these 2 aspects of their role, and the organisations need to support and monitor this aspect of their practice. There are several instances where supervising social workers and the child social workers were in conflict, and this split between the 2 social worker teams was clearly identified by Perpetrator 2 when interviewed for this review. Whilst challenge is helpful, in these cases the antagonism allowed foster carers to divide and rule, rather than the focus remaining firmly on the needs of the child.